SJC-12123, Terry Ann Selden, Calhoun v. Boyd Smith, Inc.
Good morning, Ms. Calhoun. You may proceed. You've got 10 minutes.
I am appealing this case for so many reasons. All of my rights have been illegally, criminally, civilly, religiously ignored, and worse, trampled over. And I certainly have not the background to deserve that. I was brought to this state as a child by John F. Kennedy before he was president. He decided that my family had a huge amount of knowledge with environment and NASA, and I in particular had always done that since childhood. And he wanted me to work on those issues. And I have done that my whole life, along with my family, who has created the NASA project and picked the astronauts, and I was involved with that. My aunt indeed oversaw the engineering and the mathematical things for the first space shuttle. I have a huge background from 10 different colleges and universities in science journalism, particularly investigating problem cases that are medical. And I found that when I created Church Park, I was dealing with trying to reunite groundwater that had been separated for so many decades by the emerald necklace being interrupted, and that we needed to have a reflective pool in order to reunite all the things that had been disconnected. And I did this work in New York Central Park as well on their emerald necklace. The reflective pool had a definite purpose beside its beauty. And when I told Church Park that I had created the facility and I had moved there, I never anticipated that the first day that I moved in, everything that belonged to me would be stolen instead of delivered to Church Park, despite the fact that I had licensed, bonded, and insured movers who had successfully delivered my things and stored them for years. And indeed, this morning, another item was stolen from my apartment that I had bought to replace clothing that was stolen that I needed. So far, $2,000 worth of new clothing. This morning, the Liberty of London coat I intended to wear in court. The cases that Mr. Bancroft has cited, I have researched several times in great depth. First of all, he didn't cite them correctly. The numbers were missing. The years were wrong. But each and every one of them was reversed because of the Supreme Court having exceptional circumstances, undue hardships, no malice intended, and not frivolous lawsuits, and so that the person cannot raise the bond money required, and nor are they required to. One case he cited involved a murderer and other convicted criminals. I don't fall in that category. When I reported to Church Park that they had human feces coming through my shower head, through my bathtub, through my kitchen and bathroom spigots, and that I had gotten so ill that I was in the emergency room several times and almost died, and my hair was falling out from the medicines they had to give me, they kind of just laughed it off. And I said to them, I have lived here my whole life. I created Church Park. I can help you fix all of the problems, and I will do it for free. And I have paid my rent with all of my checks saying, you still have not fixed this matter, you still have not fixed that, you still have not fixed the other thing. One of the things I found was the ventilation system having Legionnaire's disease. And I am the very famous investigative reporter who diagnosed that in Philadelphia decades ago. And I was indeed suffering from that. In fact, only yesterday, I ran into the technology staff from Wentworth that Mayor Menino had appointed to help me in 2002 when I testified before Boston City Court and as their expert and presented a 64-page report on groundwater work that I had done prior to the early 70s. I've always been your groundwater expert, and when you look at the ground and you see all those things, that's because of my work. And this Wentworth expert told me that their investigation has revealed not just E. coli, but also lead poisoning, and that is why you see all the streets torn up, especially the cross-sections where I live. In addition, I had reported that they were traveling to where the government relocated me, which is One Back Bay, which is the corner diagonally opposite the Hancock Center. Now, I was involved with the Hancock Center before they ever made the taller building. I was at MIT with Benjamin Netanyahu, and we were in architectural engineering. I also studied marine biology and ocean engineering. But we told them that they should not make the building taller because the groundwater wouldn't support it, and the pilings wouldn't support it, and they could cause severe problems in the disruption of water flow, not just here, but around the world. And I have worked on those groundwater issues around the world, in Amsterdam, in Venice, and I am considered the expert on it. And yet, they did put it up anyway, and there was always plywood in the top. We could never fix it. The new Hancock building is now sheathed in black glass, which falls out in the huge wind tunnels that the building creates. The doors must be sealed so that the staff can't come and go in them. People who walk by get hurt by it just the same as the old Hancock building with the plywood. And there has been plywood, and their window washing carriers fall off and break on people, and I've brought pieces in for evidence to all the local businesses. Also, they disrupted the Trinity Church and the pilings, which is why Hancock is responsible for repairing all those things. That meant that the bats and things that fly and live in the belfry couldn't use their radar, and I was bit by a bat, and I had to go through rabies shots, and that was also emergency room procedures. I had the scrapes to prove it. I had the filth in my eyes to prove it, which disrupted my 2 perfectly corrected cataract surgeries. I find that Ms. Pitts and Mr. Bancroft have deliberately provoked me and harassed me outside my apartment for the high holidays, which is totally inexcusable under any circumstances. I made 9 appointments which were confirmed by Ms. Pitts to deal with her and the issues she never honored. And then the night of the high holidays, which I do indeed observe, she stood outside my door banging and screaming that she demanded entrance and that I had no right to tell her it was the high holidays and I was observing them and that I had shown up for her appointments. She was going to open the door with her staff and they were going to come in and they were going to serve me some of these documents. And I finally just said to her, you can't really do this. I've shown up and shown up and shown up, and you're not honoring anything you said about fixing the human feces or fixing any of the building hunks that are falling down or the separated staircases, the handrails that are falling out. And if I hadn't reported them to Boston City, I wouldn't be now facing eviction as an illegal Hispanic woman with 1 bad eye and 2 family members on welfare. I am an American woman. I have 2 perfectly corrected cataract surgeries. and I don't have any dependents. And 60 government agencies proved it. Yet I got this eviction notice that is completely illegible and has been illegally altered for the moving company that was selected by the Boston Sheriff's Office. I don't know if you've seen it. My name is not correct. My address is not correct. The date of the eviction and the time of the eviction is not correct. So indeed, I returned to the Supreme Court, where I had filed 2 separate cases, realizing that I was not getting listened to in housing court, and that there were more issues involved than I had imagined would ever be involved. And I find that while I am sitting in court asking them to please explain to me what's going on, the judge is telling me, yes, you did indeed file everything in a timely manner, and no, don't worry, nobody will touch anything. And I said, but this particular agency, I have twice indicted for the State Attorney General's office for being unlicensed, unbonded, with no proper facilities. And I've already lost most of my belongings the day I moved in, so I only continued my lease on a month-to-month basis, and I have a right, with the security deposit in place, to find my own private insured mover and leave.
Okay, Ms. Calhoun, I'm afraid your time is up, so
Okay.
thank you. Mr. Bancroft?
I think it's good afternoon. Justices, may it please the court, Daniel Bancroft for Boyd Smith. Let me say respectfully and with some compassion, Ms. Calhoun has articulated a litany of issues, and again, respectfully, none of those are before the court. She seeks to relitigate the underlying summary process action. That action was tried before a judge. Ms. Calhoun was present. She testified. A housing specialist was sent to her apartment to investigate some of her allegations regarding damages and conditions. After all of the evidence was taken and the view was taken and the report was considered, the judgment entered for possession and approximately $13,000 in damages. That appeal, then Ms. Calhoun appealed. An appeal bond was set. The appeal bond was, the determination of the appeal bond was sent to the single justice of the appeals court, who conducted a hearing with witnesses present. Ms. Calhoun testified. I shouldn't say witnesses, the parties were present. The appeal bond was affirmed. Failure to pay the appeal bond resulted in the dismissal of the underlying case. That case is over. What Ms. Calhoun did next was file to the single justice of this court under 211.3 an extraordinary remedy that is only available when there is no other available remedy, when there is no appellate process. Here there was. Justice Spina denied without hearing her appeal to this court, and she then, under Rule 221, took a further appeal to this panel. So the only issue before you today is, did Justice Spina correctly deny her petition under 211.3? Not the summary process case, not even the appeal bond determination, not the stay that was requested and denied, because that didn't happen until after she filed her appeal to the single justice and to this court. So the only issue is 211.3, and the cases are dispositive. In the matter of appeal bond, Ford versus Brayman were both considered by Justice Spina. They continue to be good law in the Commonwealth, and they determine and are determinative of the issue here. This court, more recently than Ford and in the matter of appeal bond, reviewed and determined again that a litigant, this is in the case of Elgby versus Pine Street Inn, Elgby is E-L-G-B-E, that case was determined, and this court held, LB was not entitled to relief under 211, Section 3, because the housing court's dismissal of LB's appeal on the bond issue was subject to the usual appellate process, and again cited in the matter of an appeal bond and Ford versus Brayman. And that was a 2004 case. In 2006, I know we had some discussion about the paucity of legislative history in the Commonwealth, but Justice Kratzley, in a Superior Court case of BNB Group Boston versus Pisano, wrote, "The court in Ford versus Brayman held that there is no second level of review of the determination of the amount of the bond to be posted by a defendant who lost a summary process proceeding for possession and damages." And in that decision, considered 239, Section 5, F, and H. And every way you look at this, Ms. Calhoun's remedies were addressed. She took the appeals that were available to her, and again, our position is 211.3 affords and affords no relief here, no remedy here, because it's not apt, it's not appropriate, and should not be. There should be no further remedy available. As the court is aware, without a brief, I was not sure what to respond to. I've tried to outline what our position would be under the arguments that I could surmise. What we've heard from the appellant this morning is not germane. If the court has any questions for me, I'd be happy to answer them. Otherwise, I would rest on the papers.
All right, thank you.
Thank you, Your Honor.